if your Lordship were just to see Article 105, subclause 2. No member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in Parliament or any committee thereof. I'll pause there. This in respect of is what had to be interpreted by the court. And the cleavage in opinion between the majority and the minority is on how in respect of will be interpreted. So I just want to read, large parts of the judgment have been read by the learned amicus. If I can just trouble your Lordship with just one small passage, which is in para 47 of the judgment at page 580, PDF 580. Just one little passage, because this is the heart of
PDF page 580 of
580 of same volume 5, Narasimha Rao's judgment. If I can have your Lordship's attention at placitum C, just between C and D. My Lords have it? Page 580. If I can read that. If the construction...
579, is it?
580, my Lords. PDF 580.
Yeah.
The big numbered page will be 576, but PDF is 580. Yeah, this is para 47, which continues from the previous. Yes. Somewhere exactly halfway down the page, it says, if the construction placed by Sri Rao, your Lordships have that?
Yes.
On the expression in respect of is adopted, a member would be liable to be prosecuted on a charge of bribery if he accepts bribe for not speaking or for not giving his vote on a matter under consideration before the House. But he would enjoy immunity from prosecution for such a charge if he accepts bribe for speaking or giving his vote in Parliament in a particular manner and he speaks or gives his vote in Parliament in that manner. It is difficult to conceive that the framers of the Constitution intended to make such a distinction in the matter of grant of immunity between a member of Parliament who receives bribe for speaking or giving his vote in Parliament in a particular manner and speaks or gives his vote in that manner, and a member of Parliament who receives bribe for not speaking or not giving his vote on a particular matter coming up before the House and does not speak or give his vote as per the agreement so as to confer an immunity from prosecution on charge of bribery on the former, but denying such immunity to the latter. So by the mere act of abstaining from voting, and if he's been bribed to abstain from voting, he would be immune.
As Ajit
He would not be immune, I'm sorry. He would not be immune.
Does not be.
But if he acted and he voted in a particular fashion, he would be immune. Now, this artificial distinction, they say that it's difficult to conceive that the framers of the Constitution meant that. Such an anomalous situation would be avoided if the words in respect of in Article 1052 are construed to mean...
Ajit was not granted.
He was not. He was not. In fact, the conclusions your Lordships asked, if your Lordships come to the conclusion, I'll just come to that. In respect of in Article 1052 are construed to mean arising out of. If the expression in respect of is thus construed, the immunity conferred under Article 1052 would be confined to liability that arises out of or is attributable to something that has been said or to a vote that has been given by a member in Parliament or any committee thereof. The immunity would be available only if the speech that has been made or the vote that has been given is an essential and integral part of the cause of action for the proceedings giving rise to the liability. The immunity would not be available to give protection against liability for an act that precedes the making of the speech or giving of vote by a member in Parliament, even though it may have a connection with the speech made or the vote given by the member, if such an act gives rise to a liability which arises independently and does not depend on the making of the speech or the giving of vote in Parliament by the member. Such an independent liability cannot be regarded as liability in respect of anything said or vote given by the member in Parliament. The liability for which immunity can be claimed under 1052 is the liability that has arisen as a consequence of the speech that has been made or the vote that has been given in Parliament. This is the reasoning that the minority adopts, my lords. The conclusions your lordships wanted to see of the majority is at 604, PDF 604. No, sorry. Why is this? Sorry. Para 98, my lords, which is 608, PDF 608. Para 98. Now, these are the conclusions of the minority. On the basis of the aforesaid discussion, we arrive at the following conclusion, and the first conclusion is the one that we are concerned with, that a member of parliament does not enjoy immunity under Article 1052 or under 1053 of the Constitution from being prosecuted before a criminal court for an offence involving offer or acceptance of bribe for the purpose of speaking or by giving his vote in parliament or in any committees thereof. There's a one-page concurring judgment of Justice Reyes with the majority. That's the next page, my lords. Page para 101, your lordship will see once again the interpretation of in respect of is there. That's para 101. That's Justice Reyes. After which Justice Barucha's judgment, my lords, starts thereafter for himself and Justice Babu. And if your lordship will be kind enough to come to para 139, which is PDF page 636, 636. Para 140, para 140. Mr. Patwale had read the next para. I just thought this may be relevant. Brennan J, para 140, your lordship, sir. Brennan J, dissenting in Brewster, said that Brewster had been charged with a crime whose proof called into question the motives behind his legislative acts. He could not only not be prosecuted or called to answer for his vote in any judicial or executive proceeding, but his immunity went beyond the vote itself and precluded all extra congressional scrutiny as to how and why he cast or would have cast his vote a certain way. Neither the senator's vote nor his motives for voting, however dishonorable, could be the subject of a civil or criminal proceeding outside the halls of the Senate. The charge of a corrupt promise to vote was repugnant to the speech or debate clause. It might be that only receipt of the bribe and not performance of the bargain was needed to prove the charge, but proof of an agreement to be influenced in the performance of legislative acts was, quote, by definition an inquiry into their motives, whether or not the acts themselves or the circumstances surrounding them are questioned at trial. Furthermore, judicial inquiry into an alleged agreement of this kind carries with it the same dangers to legislative independence that are held to bar accountability for the official conduct itself. The senator's reprehensible and outrageous conduct, if committed, should not have gone unpunished, but whether a court or only the Senate court might undertake the task is a constitutional issue of portentous significance, which must of course be resolved uninfluenced by the magnitude of the perfidy alleged. These two quotes are relevant because this is effectively what the majority takes and uses as the basis for the entire judgment. See para 141. We cannot but be impressed by the majority opinion in Brewster, but with respect, are more persuaded by the dissent. These two paragraphs are read out. The majority opinion stated that the only reasonable reading of the speech and debate clause was that it does not prohibit inquiry into activities that are casually or incidentally related to legislative affairs, but not a part of the legislative process itself. Upon this construction of the speech or debate clause, it came to the conclusion that a court could investigate whether Brewster had taken a bribe to be influenced in the performance of official acts in respect of his action, vote, and decision on postage rate legislation. With respect, we cannot regard the act of taking a bribe to vote in a particular way in the legislature to be merely casually or incidentally related to legislative affairs. And then they rely on this Library of Congress publication and they approve it, my lords, that the extract is there. And then, my lords, at para 143, your lordships have seen the conclusion that they have drawn after that. Next page, PDF 638. Our conclusion is that the alleged bribe takers, other than Ajit Singh, have the protection of 1052 and are not answerable in a court of law for the alleged conspiracy and agreement. The charges against them must fail. Ajit Singh, not having cast a vote on the no confidence motion, derives no immunity from Article 1052. I ask myself, my lords, if I were to take a bribe and then have second thoughts, a prick of conscience, and I decide not to vote as the bribe has demanded, I would not have my immunity. But if I were a good boy and I acted as per the bribe and I went and voted in accordance with that, I would suddenly be immune. This absurdity, my lords, has led to, when this judgment itself came out, contemporaneously, there were many criticisms of this, and a slew of articles came out. Just one of them by an author. I will just read one sentence from that. In the nearly half century of its existence, this is Mr. Nurani writing in his Constitutional Questions on Citizens' Rights. In the nearly half a century of its existence, few rulings of the Supreme Court incurred such odium, and so deservedly, than that so merrily handed down on 17th April 98 in the Jharkhand Mukti Morcha case. It holds that legislators, MPs, or MLAs who take bribes enjoy constitutional protection from prosecution for their crimes. Lesser mortals, however, who offer the bribes do not, and this in the name of free speech and free vote in the House. If I may draw a parallel, my lords will recall in section 6A, 6 capital A, of the Delhi Special Police Establishment Act, there was the single directive which had been struck down in Vineet Narayan, and then they brought it back by way of statute. Your lordships had occasion sitting in 5 to entertain the challenge to section 6A. Section 6A provided that if you are a particular class of officer, a consent is required in order to prosecute you. You created 2 classes of officers. And that was struck down by your lordships. The effect of this judgment is that it says that you are welcome to take bribes provided you are acting in accordance with that bribe as far as the House is concerned. But if any other individual, if a PWG engineer on the street is taking a bribe, there is absolutely no immunity available to him. It is not Article 105 and 194. These provisions are not meant to spread that limited dragnet of protection so far afield that a taking of a bribe for this tenuous purpose is to be protected. And if I may just for a minute take your lordships to one para from Kalpana Mehta, my lords, which is in this same volume. It's at PDF 1325. This is Kalpana Mehta, my lords, PDF 1325. It starts at 1214. PDF 1214. This is the Constitution Bench of my lords dealing with parliamentary committee reports and whether privilege attached to that. I just want to read one paragraph, actually 2 paragraphs. One is para 221, which is at PDF 1325. Do my lords have that?
Yes.
1324, 1325. This is my Lord Justice Chandrachud's judgment as part of the bench. My Lord has para 220, 220.
Yes, that is 1324.
1324, PDF 132. Now this is also Constitution bench. Para 220 deals with my Lord's summation of P.V. Narasimha Rao. Para 221 is with reference to the submission of the Attorney General at that point. And I just want to read that para after para 221's extract. At page 1325, just after the extract, your lordships have the view. 1325, second paragraph.
Yes.
The view. Yes, the view of the minority was that the offense of bribery is made out against a bribe taker either upon taking or agreeing to take money for a promise to act in a certain manner. Following this logic, S.C. Agarwal J. held that the criminal liability of a member of parliament who accepts a bribe for speaking or giving a vote in parliament arises independent of the making of the speech or the giving of the vote, and hence is not a liability in respect of anything said or any vote given in parliament. The correctness of the view in the judgment of the majority does not fall for consideration in the present case. Should it become necessary in an appropriate case in future, a larger bench may have to consider the issue. It is our submission that it squarely falls for consideration here because the impugned judgment in the main case deals with this. And, my lords, the defense, Mr. Ramachandran was very fair to disclose, relies on the majority in Narasimha Rao. Now, the majority in Narasimha Rao does not come to his aid if it is overruled. And the conclusion is there for all to see, my lords. Just 2 small things in addition. One is the judgment in Dawoodi Bora, that's also here, but I'm not taking a lordship's, fairly clear that the only other avenue apart from concurrent benches referring matters to a larger bench if there is a disagreement is where it is placed on the administrative side. Now, Your Lordship would have seen the orders which were passed in this case. The first order was by a bench of 2, the second order was by a bench of 3.
Three.
Now, that bench of 3 placed it on the administrative side. The last sentence places it on the
At least 5 judges.
at least 5 judges for consideration. This is only to meet with Mr. Ramachandran's submission that it doesn't call for a reference, or even the Attorney General's. That was a call that was taken on the administrative side to place it before this bench. So now that this bench is already constituted for it, there's no question of reversing it, because that's a call that's been taken, and that call is not open to judicial review because it was taken on the administrative side. Now, that having been done, my lords, and keeping in mind that between 1998, when this judgment was delivered, and now, we have had substantial progresses as far as the law is concerned. In fact, in the same judgment of Kalpana Mehta, while answering the reference at para 271, Your Lordship noticed the passage of time from the time of independence till now. That's at page 1345, bottom. I won't take more of your time by reading it out, but para 271 and para 274 talk about how the passage of time and the changes that have been wrought. Specifically this sentence, we no longer live in a political culture based on the subordination of individuals to the authority of the state. Our interpretation of the Constitution must reflect a keen sense of awareness of the basic change which the Constitution has made to the polity and to its governance. This is page 1346, the last sentence of para 271. Now, in the 25 years since P.V. Narasimha Rao's judgment has come, we've had many developments, including the fact of Article 14, Article 1921, individual rights being expanded, public morality, this fell from Your Lordships, that has undergone a sea change and an expansive interpretation has been given. Also, my lords, in the CVC's case, CVC Thomas's case, which was Center for Public Interest Litigation, with the citation, institutional integrity was coined as an important phrase to be borne in mind when dealing with a writ of quo warranto. Now, if we keep all these phrases in mind, my lords, and consider the developments in law since then, clearly all these principles are now available, perhaps to persuade a larger bench that could be constituted in this case to accept that the Narasimha Rao minority has the correct view and why it should be revisited. I think those developments also need to be borne in mind so that we can reverse the idea that a parliamentarian or a legislator can have some sort of constitutional immunity only because he has acted in terms of the bribe. In the US, recently, this Senator Lindsey Graham was questioned. He's been arraigned and he's being questioned about the phone calls that he made during the elections for Georgia. He sought to appeal that, saying it's a privilege which he has under the same Article 1, Section 6 of the US Constitution. That has been rejected by the US Supreme Court, saying, look, we can't expand that at the moment. So they haven't even granted certiorari for that. But it is a subject that is keeping courts engaged in those jurisdictions where we haven't stepped far enough. But in the US, in the UK, everywhere else in the developed world, we have gone far enough to say, as the majority in Brewster did, that you will not have this protection of immunity. India stands out like a sore thumb with having this wafer-thin majority in Narasimha Rao, changing what should be right. Therefore, I join the amicus completely. This matter needs to be referred to a larger bench and this judgment needs to be reconsidered. I'm most grateful.
Sorry.
1 minute.
Who are you appearing for?
Yeah. Pardon,
Who
sir.
are you appearing for?
NB Tiwari, intervener.
Intervener.
Yeah. Sir,
You are supporting the reference or you are opposing the reference?
sir, we are accepting the court and we are putting the independent points regarding this matter. Only points
Do
to sort.
you want us to make a reference or you are opposing the reference?
Are in favor of the reference to the law.
Reference.
So please, sir. Only
Right,
points.
2 minutes, yes.
Please. Sir, the point one is that what was the intention of our constitution makers under Article 105 and 194 whether immunity from criminal prosecution for taking bribes or money for vote or speech in House to MP MLAs is creating a different class who are allowed to corrupt the basic structure or the foundation of the democracy. First point is that. And second is that whether in democracy like India, a voter can expect from his elected representative that he should be allowed to take money or bribe for speech or votes in House. Sir, we are deciding from the point of view of the lawmakers from the past decisions, but we are not considering the point of view of our constitution makers and like as the common voter, because in India, we have the constitutional supremacy, not the parliamentary supremacy. So the reference should be the larger bench in this.
Yes, thank you.
Thank you.
Yes, Mr. Attorney General.
I mean, I stand by what the attorney has said in the earlier occasion. And not that I remember a catchy phrase of one of the earlier attorney generals of US, somewhere in the 90s, about the sanctuaries of corruption. That's so Parliament or legislators not become sanctuaries of corruption. That's well taken. But I also said that probably the court is now called upon to sit in review over Narasimha Rao on a particular fact situation, then one can understand that. But we are now thinking in the abstract. The review is over, a curative petition is withdrawn. Now in the abstract, on the facts of this case, I don't think there's need for even applying Narasimha Rao. If I am clear on that, if Narasimha Rao will not even apply, then what is that the question which the court need to formulate and doubt or accept the minority view or go with the majority view? I have not assisted the court either way in my submission. My only, sorry. So if you go entirely with it,
Are you abiding by the stand which was taken by the Attorney General in Narasimha Rao?
let me tell you. Now, what the attorney argued, is entirely what I certainly as a proposition of law. But I, as an officer of the court, now there is a view taken by the bench. Now, let me just a few preliminary observations. Now, paragraph 74 and 77, the minority view, if you have to go by that and take it as a view of the bench in Narasimha Rao, then the appeal will have to be dismissed because the appellant will have to be prosecuted. I say yes, the appellant will have to be prosecuted on the facts of this case, not because Narasimha Rao is rightly or wrongly decided. Because I started by saying my observation statement in the morning saying that Narasimha Rao does not fall for application the facts of this case.
But Mr. Attorney General, the impugned judgment of the High Court relies upon the judgment in Narasimha Rao.
No, therefore they could not have relied upon the judgment.
Difference.
The appellant could not have relied upon the judgment in Narasimha Rao.
Ramchandran also rests on the judgment of the majority.
No, that's how they came, that's how they traveled this length. So
That's right. So we have
otherwise the matter would have been over somewhere else. So the question of invoking Narasimha Rao does not arise on the facts of this case. It's a very important distinction in order to, yeah.
Yeah.
Whether a narrow view is to be taken or an expansive view to be taken will then be dictated by the facts of a given case. But now, as I said, in the abstract, a narrow view would probably comment to the court or a broader view. Because as I see the law, which has grown over a period of time, US, UK, Canada, Australia, I mean, on the one hand, there's a need to keep the integrity of the speech and debate clause, the protection of immunity on the one hand. Same time, an overbroad protection can probably bring in distortions on the functions of a parliamentarians. So on the balance of these considerations, the majority view has taken a particular perspective. So if for the purpose of this case, I am a little worried whether on the facts of this case, there's a need for a larger reference to a larger bench? The answer would be no. And the prosecution will have to go on. But I stand with the other principle that how do you really expound Article 194 or 105? Maybe there is a case made out for expounding it.
Oh,
But
yeah.
as I said that,
We'll take a short or the criminal appeal arises from a judgment and order dated 17 February 2014 of the High Court of Jharkhand in writ petition criminal 128 of 2013. Next. An election took place on 30 March 2012 for two members of the Rajya Sabha representing the state of Jharkhand. Full stop. The appellant was a member of the Legislative Assembly from a seat reserved for the scheduled tribes and contested as a candidate belonging to the Jharkhand Mukti Morcha. Full stop. The allegation against the appellant is that she accepted a bribe from an independent candidate for casting her vote in his favor. However, according to the appellant, she did not cast her vote in favor of the alleged bribe giver and in fact cast her vote in favor of a candidate belonging to her own party. This having emerged from the open balloting for the Rajya Sabha seat. Full stop. Moreover, the election was rescinded. Moreover, the round of election in question was rescinded and a fresh election was held at which the appellant voted in favor of a candidate belonging to her own party. Full stop. The appellant moved the High Court for quashing the charge sheet and the criminal proceedings instituted against her, relying on the provisions of Article 194(2) of the Constitution. The High Court declined to quash the proceedings on the ground that the appellant had not cast her vote in favor of the alleged bribe giver. Full stop. That has given rise to the appeal. Next. On 23 September 2014, when the proceedings were placed before a two-judge bench, the court was of the view that, into invert commas, since the issue arising, it should be really, don't say into invert commas, that since the issue arising for consideration, into invert commas, is substantial and of general public importance, into invert commas complete, it was required, it should be placed before a larger bench of 3 judges. Full stop. On March 2019, when a bench of 3 judges took up the appeal, it noted that the gravamen of the charge against the appellant is that she had accepted a bribe to vote in favor of a particular candidate in the Rajya Sabha election for Jharkhand. The precise question, as the 3-judge bench noted, comma, as a three-judge bench observed, comma, was dealt with in a judgment of a constitution bench in P.V. Narasimha Rao versus State, 1998, 4 SCC 626. Full stop. While two judges on the bench, into brackets, Justice S.P. Bharucha and Justice B.N. Agarwal. Justice S.C. Agarwal, it was not B.N. Agarwal. Justice S.C. Agarwal and Justice G.N. Ray were of the view that was A.S. Anand. Right. Justice A.S. Anand took the view that the protection under Article 1052 and correspondingly Article 194, bracket 2 of the Constitution and the immunity granted would not extend to cases where bribery for making a speech or vote in a particular manner in the House is alleged. The view of the majority was to the contrary. Full stop. The three-judge bench hearing the present appeal was of the view that, to invert commas, having regard to the wide ramification of the question that has arisen, comma, the doubts raised and the issue being a matter of substantial public importance, into invert commas complete, it required to be referred to a larger bench as may be considered appropriate. Full stop. The matter has been placed pursuant to the administrative directions of the Chief Justice before this bench of 5 judges.
Otherwise,
We need to take note of that. I mean, give us
a
a PDF page. Just give us the PDF page because that is not shown to us in the morning.
page 1 minutes.
Page
It's
1.
not, it's not there on the PDF. It's not there. It's an order dated 15/11/22.
You have a copy of it?
15/11/22. We just see if you have a printed.
Does anybody have a printed copy?
I will share from her.
Mr. Shankarnath, you may not get it back. Huh?
We'll share one or two printed copies.
Just 2 lines, list on 15.
Thank you. Return with thanks. Yes. We must note at the outset that Mr. Raju Ramchandran, Learned Senior Counsel appearing on behalf of the appellant, submitted that, strictly speaking, a reference of the correctness of the decision in P.V. Narasimha Rao, bracket Supra, may not, strictly speaking, be necessary in the facts of the present case. Let's stop. This submission has been also advanced by the Learned Attorney General for India. Let's stop. Mr. Ramchandran, in his note of submissions, as well as in the course of the oral arguments, submitted that none of the contesting parties has challenged the ratio in P.V. Narasimha Rao, Supra. Full stop. On the contrary, it is urged, that the contesting parties are ad idem on the ratio. And what is thought to be contested is the applicability of the judgment. Full stop. The respondent, it is submitted, urges that the judgment does not apply in the instant case as polling for the Rajya Sabha election was held outside the precincts of the House of Parliament, outside the precincts of the House, this will be the Legislative Assembly, and cannot be taken as a proceeding of the House in a manner similar to a no confidence motion. Let's stop. On this basis, it has been submitted that the reference would not be warranted. Let's stop. At this stage, it would be necessary to note that Mr. R. Venkatramani, the Attorney General for India, has also advanced the same submission, relying on the decisions of this court in bracket 1. मैं आपको citation दे देता हूं, आप पूरा नाम ले लो. 1984 to SEC 404, semicolon, bracket 2, 1997 11 SEC 111, and semicolon, bracket 3, 2006 7 SEC 1. Next. Before we before proceeding further, it would be appropriate to note that the judgment that a review petition, into brackets, review petition number 2210-27 of 1998, review petitions, namely, review petition numbers 2210-27 of 1998 were instituted before this court to seek a review to questioning the correctness of the decision in P.V. Narasimha Rao. Let's stop. The petitions for review were dismissed on the ground that there was a delay, on the ground of delay in a judgment reported as State bracket CBI bracket SPE versus P.V. Narasimha Rao 2001 9 SEC 249. Full stop. Apart from this, a petition under Article 32 of the Constitution bracket writ petition civil D-7490/1999 bracket was instituted before this court by an order dated 1 May 2000 in Center for Public Interest Litigation versus Union of India 2009 SEC 393. The petition was referred to a bench of 5 judges while noticing a submission regarding the maintainability of the petition. Full stop. Eventually, the petition was dismissed on 18 July 2002 on the ground that the petition did not meet the requirements.
Order only says dismissed keeping in view the judgment.
Was dismissed keeping in view the judgment in Rupa Ashok Hura versus Ashok Hura 2002 4 SEC 388. Full stop. In the present case, the The bench of two learned judges was of the view that, having regard to the significance of the issues raised, it should be placed before a bench of three judges. But stop in the same manner. The bench of three judges was of the view, for the reasons which have been noted earlier, that the entire issue required to be considered by a larger bench. But stop. Such a decision has been made on the administrative side to constitute a bench of five judges for that purpose. Full stop. We are not inclined at this, apart from the significance of the issues raised, which shall be explained in brief a little later in the course of this order, we are not inclined to accept the plea that the correctness of the decision in P.V. Narasimha Rao, bracket Supra, does not arise in this case. Firstly, it is common ground that the impugned judgment of the High Court relies upon the judgment of the majority in P.V. Narasimha Rao. Secondly, it is beyond doubt that the defense itself relies on the decision of the majority. Full stop. The correctness of the view which has been propounded in the judgment of the majority in P.V. Narasimha Rao would have to be inquired into during the course of the hearing of the criminal appeal. Therefore, as both the benches of 2 and 3 judges, respectively in the present case, have opined, it becomes necessary for us to determine prima facie as to whether a reconsideration of the judgment in P.V. Narasimha Rao is warranted. Full stop. The controversy turns on the interpretation of the provisions of Article 1052 of the Constitution, which full stop, and don't say full stop, and the equivalent article, Article 194, bracket 2, semicolon, the former dealing with the powers, privileges, and immunities of the members of the Houses of Parliament, and the latter of those applicable to the members of the state legislatures. Next, Article 105, bracket 2 provides as follows. तो copy कर लीजिए. The crucial words of Article 1052, the words of the language of Article 1052 indicates that an immunity attaches to a member of Parliament, into invert commas, in respect of anything said or any vote given by him, into invert commas complete, in Parliament or any committee thereof. Full stop. The expression anything said or any vote given would postulate that the immunity attaches in respect of conduct which has taken place, namely the giving of a vote or upon speech which is made in Parliament or in any committee of Parliament. Full stop. The expression in respect of anything said or any vote given arose for consideration squarely before the Constitution bench in P.V. Narasimha Rao. Full stop. The charge in that case was that the bribe takers had taken bribes to secure the defeat of a no confidence motion on the floor of the House. Full stop. In analyzing the expression, In analyzing the above expression, Justice S.P. Bharucha took the view that Article 105 bracket 2 would have to be interpreted broadly, and so interpreted would protect a member of parliament against proceedings in court that relate to or concern or have a connection or nexus with anything said or a vote given by him in parliament, into brackets, paragraph 133 at page 729. The court was of the view that the nexus between the alleged conspiracy and bribe and the no confidence motion was explicit, the charge being that the alleged bribe takers had received bribes to secure the defeat of the no confidence motion. The Attorney General for India, in that case, had urged before the Constitution bench that though the words in respect of must receive a broad meaning, the protection under Article 1052 is limited to court proceedings that impugn the speech that is given or the vote that is cast or arises therefrom. Stop. Noting that the object of the protection was to enable members to speak their mind in Parliament and vote in the same way without the fear of being made answerable. The judgment of Justice S.P. Bharucha contains the following observations. Just copy down. Para 136 at PDF page 636. I'll give you the first three words. It is not enough to the end of the paragraph. Let's stop. The court, Justice Bharucha observed, Justice S.P. Bharucha, the learned judge observed that he was conscious of the seriousness of the offence which the alleged bribe takers were said to have committed, and that by reason of the lucre, L-U-C-R-E, that they had received, they enabled the government to survive. But, the judgment opined, into inverted commas, our sense of indignation should not lead us to construe the Constitution narrowly, impairing the guarantee to effective parliamentary participation and debate. To invert commas complete. Para 137 mein le lo, page 636 ko le. However, the court was of the view that the immunity which attached to the other bribe takers would not attach to a member of parliament who had not cast the vote on the no confidence motion and would not therefore be entitled to the protection. Would stop. The contrary viewpoint of the minority in P.V. Narasimha Rao was espoused in the judgment of Justice Agarwal. Would stop. The learned judge observed that the expression, into invert commas, in respect of would have to be construed in its true perspective. Would stop. The judgment emphasized that the object and purpose of Article 105(2) of the Constitution is to enable members of Parliament to speak freely or to cast their votes without fear of consequences. Would stop. In that context, the divergence in view with that of the majority, with that of Justice S.P. Bharucha, emerges from the following extract in paragraph 47 of the judgment. Copy down at page 579 PDF, paragraph 47. Justice Agarwal, in the course of his judgment, also dwelt on the issue as to when the offence of bribery is made out or complete. Would stop. According to his view, according to the view of the learned judge, the offence of bribery is made out against the receiver if he takes or agrees to take money for a promise to act in a certain way. The offence would be complete with the acceptance of the money or on the agreement to accept the money being concluded and is not dependent on the performance of the legal promise by the receiver. Full stop. The receiver of the money will be treated to have committed the offence even if he were to default in the performance of the bargain. Hence, the learned judge held that for proving the offence of bribery, all that is required to be established is that the offender has received or agreed to receive money for a promise to act in a certain way. And it was not necessary to prove further that he had actually acted in the way as promised. Would stop. The third judgment in P.V. Narasimha Rao, in P.V. Narasimha Rao's case, was delivered by Justice G.N. Ray. Would stop. Justice G.N. Ray observed that he was unable to concur with the finding in the judgment of Justice Agarwal that a member of Parliament does not enjoy immunity under Article 105(2) from being prosecuted before a criminal court for an offence involving offer or acceptance of bribe for the purpose of speaking or giving his vote in Parliament or in any committee. Full stop. A reading of the judgment of Justice G.N. indicates that the learned judge concurred with Justice Agarwal in coming to the conclusion that bracket 1, a member of parliament is a public servant under section 2 bracket C of the Prevention of Corruption Act 1988, and 2, since there is no authority competing to grant sanction for the prosecution of a member of parliament under section 19(1) of the Prevention of Corruption Act 1988, the court can take cognizance of the offences mentioned in the provision, but before filing a charge sheet against a member of parliament in a criminal court, the prosecution agency must obtain the permission of the chairperson of the Rajya Sabha, or as the case may be, the Speaker of the Lok Sabha. Full stop. Hence, on the above two issues, Justice G.N. concurred with the judgment of Justice Agarwal. However, on the interpretation of Article 105, bracket 2, Justice Ray concurred with the judgment of Justice S.P. Barucha, speaking for two judges. Full stop. Hence, the judgment of Justice S.P. Barucha on the interpretation of Article 105, bracket 2, represents the view of the majority of three learned judges. Next. We may note at this stage that we have heard that besides Mr. Raju Ramchandran, learned senior counsel, and Mr. R. Venkatramani, learned Attorney General for India, we have also heard Mr. P.S. Patwalia, learned senior counsel, who has been appointed as a amicus curiae to assist the court, and Mr. Gopal Shankar Narayan. Intervener के लिए भी नाम दे दीजिए उनका. Next. We are inclined to agree with the submission of the learned amicus curiae and Mr. Gopal Shankar Narayan, learned senior counsel, that the view which has been expressed in the decision of the Constitution Bench in P.V. Narasimha Rao requires to be reconsidered by case may be the state legislature, must be free to express their views on the floor of the House or to cast their votes either in the House or as members of committees of the House without fear of consequences. Full stop. While Article 19(1)(a) of the Constitution recognizes the individual right to the freedom of speech and expression, comma, Article 105(2) institutionalizes that right by recognizing the importance of the members of the legislature having the freedom to express themselves and to cast their ballots without fear of reprisal or consequences. Full stop. In other words, the object of Article 105(2) or Article 194(2) does not prima facie appear to be to render immunity from the launch of criminal proceedings for a violation of the criminal law, which may arise independently of the exercise of the rights and duties as a member of Parliament. Secondly, in the course of his judgment, in PV Narasimha Rao, Justice S.C. Agarwal noted that if the construction in support of the immunity under Article 105(2) for a bribe taker were to be accepted, comma, a member would be liable to be prosecuted on a charge of bribery if he accepts the bribe for not speaking or for not giving his vote on a matter under consideration before the House, but he would enjoy immunity from prosecution for such a charge if he accepts the bribe for speaking or giving his vote in Parliament in a particular manner, and he in fact speaks or gives his vote in Parliament in that manner. Full stop. This anomaly, Justice Agarwal observed, would be avoided if the words "in respect of" in Article 105(2) are construed to mean arising out of. In other words, in such a case, the immunity would be available only if the speech that has been made or the vote that has been given is an essential and integral part of the cause of action for the proceedings giving rise to the liability. Semicolon. Bracket. Thirdly, the judgment of Justice S.C. Agarwal has specifically dwelt on the question as to when the offence of bribery would be complete. Full stop. The judgment notes that the offence is complete with the acceptance of the money or on the agreement to accept the money being concluded and is not dependent on the performance of the illegal promise by the receiver. Full stop. The receiver of the bribe would be treated to have committed the offence even when he fails to perform the bargain underlying the tender and acceptance of the bribe. Full stop. This aspect, bearing on the constituent elements of the offence of a bribe, finds elaboration in the judgment of Justice Agarwal but has not been dealt with in the judgment of Justice S.P. Barucha, in the judgment of the majority. Full stop. We've already noted above that the efforts to have the efforts in seeking a review of the judgment in P.V. Narasimha Rao and later in proceedings under Article 32 of the Constitution did not bear fruit. Full stop. One of us, into brackets, Mera naam likh lo, while delivering the concurring opinion for a constitutional bench in Kalpana Mehta versus so and so, page 12144, had occasion to observe that the correctness of the view in P.V. Narasimha Rao would fall for reconsideration in an appropriate case in future, should it become necessary to do so. Full stop. For the above reasons, prima facie at this stage, we are of the considered view that the correctness of the view of the majority in P.V. Narasimha Rao should be reconsidered should be considered by a larger bench of 7 judges. But above all, it must be noted that the purpose of Article 105(2) and Article 194(2) is to ensure that members of the Parliament and of the state legislatures are able to discharge their duties in an atmosphere of freedom without fear of the consequences which may follow for the manner in which they speak or exercise their right to vote on the floor of the House. Full stop. The object clearly is not to set apart the members of the legislature as persons who wield higher privileges in terms of an immunity from the application of the general criminal law of the land, which citizens of the land do not possess. We accordingly request the Chief Justice, the registry, to place the paper before the Chief Justice for constituting a larger bench of 7 judges. This part I also said that they should.
My only concern was that the appellant does not get the benefit of this long reference because the prosecution, the long pending prosecution, and then
Sorry.
the appellant in this case ought not to get the benefit of this.
Let it be.
That's my concern. It's all.
What we'll do is,
Yes.
we have heard this substantially. In all probability, we'll constitute a bench in the next week or two and we'll get another
Yes.
bench of 2 judges and we'll resolve it. Because there's no point in again now putting this in the whole loop.
Correct.
Because you've
That-
all argued
I
for
would
such a long
agree.
time, the learned
That
attorney
would
has
be
argued.
Yes.
So I think what we'll do, we'll just, we'll notify the bench.
We
we'll
are
try-
right on the question that he doesn't get a benefit of Narasimha Rao either way.
Yes.
Then why should it hang on here?
I think what we'll do is I'll try and constitute a bench in the next week or two. And because really, I mean, all the
Then,
pleadings are complete,
yes, correct,
everything is here before us.
Yeah.
I only
So
have
we'll
two more
resolve
copies
it
of
once
the
and for all. Sorry?
Then there's a set of questions that
You'll have to get two more of these,
And
yes. I can share one of mine because I have one at home now, you know.
then that will be constitution as understood by Malaran. No, then the question to be framed, to be placed before the larger bench, then is only the question of correctness of the majority view, or, because then you open a canvas too wide.
So we'll say only the correctness of the majority view on the interpretation of Article 105
Therefore,
too.
your lordship would go into the interpretation of the article. I mean, it
That
have
would
to
open up a large canvas.
Yes, yes.
7 judges, I mean, we must open up a large canvas. 7 judges is for that.
And Lord, the amicus may be requested to continue to a seven judges also.
Please do
I'm
continue.
not going anywhere now.
You know, Mr. Attorney, what will happen is if you were to lose this opportunity, I mean, we would have, the easiest thing is to close it because we would have closed it in 5 minutes.
Correct.
But you know, God knows when this opportunity will arise before a constitution bench in the future to, I mean, we may still accept the contrary viewpoint and come to the conclusion that on the balance, you know, Justice Barucha's view was right. It was a more conservative view. He felt that, look, that's the correct view. I mean, we may still come to that conclusion, but to even reconsider this may probably take another 2 decades, you know, because who knows which case will arise again for us to. So we shouldn't allow an opportunity to go by without on
Yes,
such an
we
important
certainly-
issue which concerns
Certainly,
our
I would
polity.
like to
Actually.
assist the court, but only I want to have that outer limits of expanding. Sometimes the inclination of the court to go a little beyond what may be necessary to look into. I was only trying.
Issue itself is very limited only.
That's
Issue is very
Just on the
limited.
construction of
very
194,
limited question.
read with
Because as I said, even today, no, I think Parliament has enacted a law on this immunities and privileges. Because there's a subject where certain
If a person accepts
will always
the bribe,
elude.
if a person accepts the bribe and votes or abstains from voting, then immunity. If a person accepts the bribe and doesn't fulfill their bargain,
If he
That
abstains,
way- that
he
way-
is punished. He is punished for that.
if he abstains,
He is punished.
That may be another dimension of cheating or
It
dishonesty.
turns the whole article on its head actually. Then you are not giving immunity for anything. What is
To
it?
be or not to be
very- that is the key part of it. You know, that is the key part. Otherwise, if you just look at the words in respect of, there are a number of judgments which say in respect of must be construed very broadly,
Yes, yes.
whether in commercial law or in the constitution itself. But this part really is a special issue which arises in relation to Article
To
105.
vote or not to vote is a question.
To ditch or not to ditch.
Thank you. Thank you very much, Mr. Patwalia, Mr. Shankanayan, Mr. Attorney, and Mr. Ramchandran. Thank you so much.
Would my lords be
We
convening?
missed you in Article 370 though.
Unless would my lords be convening for the, reconvening for the regular matter?
No, I think with just 15
Because I had a
minutes left.
difficulty in 101, I can mention that
No,
tomorrow
it's
morning
just,
also.
you can mention in the
Please
morning.
have it next week, I can.
You can just ask our junior to mention if you're not in court tomorrow. No
No,
problem.
I had a difficulty after an hour. It's 101.
No problem. Just ask if you are in difficulty, ask your junior to.
I'll come in.
He'll accommodate.
Others, I had a request in 102, same request, my lord.
Because provided people, after you keep us busy for the rest of the day. Thank you.